Good evening. My name is Greg Schaller, and I'm the director of Centennial Institute. Thank you for being here. We have quite a few other people who registered, so I think they'll probably be slowly coming in here, hopefully, but I think we'll get started now. This has been a very difficult week for us. I know a lot of people on our campus, a lot of other people were greatly impacted by Charlie Kirk. He inspired a lot of people. He was bold in his sharing of his faith. He had a great love for America, and he didn't appreciate it, those people who were highly critical of it without much factual basis oftentimes. So he was a great defender of America as well, as a defender of his faith. So I'd ask us to stand and have a moment of silence, and following that, we'll have Lucy, Caleb, and Aiden come up, and they will do our prayer, pledge, and introduction of tonight's speaker. So please bow your heads with me. Thank you.
Would you all join me in prayer? Father, thank you for the opportunity to gather together to discuss the important topic of our nation's origins. As our fathers have handed down such a rich tradition, give us strength as we work to recover it. As you command in your word, help us not to cross the ancient boundaries which our fathers have set. Help us to restore our understanding of being a nation under God. Strengthen us now, especially as we grapple with the harsh realities of the evils of a godless nation that we experienced this last week. Lord, be with the family of Charlie Kirk, who now mourns his absence. Raise up men to follow in his footsteps and carry on his mission as a servant of his country and of Christ. Be with all those involved in the shooting at Evergreen High School, along with those struggling from the assassination at Utah Valley University. Bring justice on the wicked and lead those who are perishing to repentance. Thank you for bringing us our speaker, and please guide him and us into the truth. In Christ's name, amen.
If you please join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, and liberty with justice for all.
I am honored to introduce tonight's speaker, Dr. Kody Cooper. Dr. Cooper is an associate professor in the Institute of American Civics at the Baker School of Public Policy and Public Affairs, University of Tennessee, Knoxville. He is the author of The Classical and Christian Origins of American Politics, Political Theology, Natural Law, and the American Founding, and Thomas Hobbes and the Natural Law. His essays have appeared in various outlets, including Newsweek, New Oxford Review, Public Discourse, Crisis, Law and Liberty, First Things, Return, and The Federalist. He lives with his wife and 9 children in Tennessee. Please join me in welcoming Dr. Kody Cooper.
Smarter than the machine. Okay. Guess I need to update that because there's another on the way. Well, it's a pleasure. And I couldn't but think, oh, how many times did John Elway rip my heart out as a young Kansas City Chiefs fan? It's 3rd and 9, and somehow he scrambled for 10 yards every stinking time. So that's painful, but I guess it hasn't been so bad to be a Chiefs fan in recent years. Maybe for the rest of the country, not so much. So I somehow I've survived that childhood trauma. Now I guess you heard about me. Maybe the most important thing to know about me is that I'm a father of many children. There's lots of pros to having so many kids. There's also some cons. One of my favorite pros is that prized by Frank Gilbreth Sr., who you may remember as the zany dad from Cheaper by the Dozen. His kids thought he had so many children because he loved having an audience. And I must say, I do like having dad jokes. So I'll actually but I'll try my best. And Christian origins of our constitutional order and focus in on what I think is the classical and Christian natural law tradition's role in the founding. So when I think about how to trace, our founding, sometimes I like to think in terms of dates, of important dates. So we could look back to, say, April 30th, 1789, and this is when Washington is sworn in as our first president, right? So you have sort of the inaugural government under the Constitution. That's one date we could look to. And our Constitution requires an oath or affirmation to uphold and defend the Constitution, which presupposes a kind of moral order, a moral necessity to tell the truth, and to keep one's promises. We can go back further still to June 21st, 1788. This is the day that New Hampshire becomes the 9th state to ratify the Constitution, thereby making it law. Because the Constitution was only proposed, was not imposed on the people, and 9 states had to ratify it before it would become law. And this underscores the idea of the sovereignty of the people to accept or reject the Constitution. Itself an authority deeply rooted in their fundamental dignity as human beings. But that also points us back to September 17, 1787, the day the Constitution was signed in Philadelphia at the Constitutional Convention. Itself a product of human reason, deliberating, discussing, compromising. And indeed, all of these days are significant, but I think they point us back still further to another date without which the Constitution, our constitutional order, is unimaginable. December 23rd, 1783, perhaps the most forgotten, but maybe one of the most important dates in American constitutional history, when Washington lays down the sword. He lays down his commission as general at the old Senate chamber in Maryland. And this was the moment in which sort of the great man of the era, who King George III later would say, who was the greatest man of the age, maybe did his greatest act of statesmanship to affirm the rule of law, not men. And the rule of law was that we'll lay down the sword, and we still have to this day the cherished institution of civilian control of the military, which is not something that's easy to achieve, and which many other republics and democracies have failed to keep in the Western Hemisphere over the years. Okay, and of course, Washington's service in the war presupposes another date, July 4, 1776, when the Declaration is published to the world, which appeals to the laws of nature and nature's God to justify separation from the British and frame a new government that would secure the unalienable rights to life, liberty, the pursuit of happiness. And the founders appeal to the laws of nature and nature's God. Their appeal to the natural law tradition was not a one-off appeal. It was not done in a void or a vacuum. To understand it, we need to still go back further. We had to excavate a little further. Okay, this is the last date, March 22nd, 1765. Does anybody know what happened on that date? Okay, you can yell it out. It can be quasi-participatory. The Stamp Act is passed by Parliament. What was the Stamp Act? Well, Parliament sought to raise new revenues through taxation, and this sort of new set of taxes generated this great transatlantic contest that took place between 1765 and 1776. Essays, tracts, newspaper articles, speeches, sermons, debating the justice of the enactments of Parliament. It generated this transatlantic discussion about, okay, what does it really mean to be colonial, Englishmen? What are our rights? What are the nature and limits of Parliament's power to do this without our consent? So the founders themselves understood the importance of this era of the so-called pamphlet debates. John Adams, writing to Jefferson, said, "The revolution was in the minds of the people, and this was effected from 1760 to 1775. In the course of 15 years before a drop of blood was drawn at Lexington, the records of 13 legislatures, the pamphlets, newspapers, and all the colonies ought to be consulted during that period to ascertain the steps by which the public opinion was enlightened and informed concerning the authority of Parliament over the colonies." So Adams was saying, look, you've got to go back and you've got to look at this time period and what was being said, what was being thought. If you want to understand the fundamental sort of frame of the American mind, its moral and political philosophy that pushes them toward revolution. And so the key question is going to be, what is Parliament's authority? Does it have sort of sovereignty? Now, you can try to imagine with me, and it's hard to do this, but you can still today in Philadelphia see the city tavern. Imagine if you were a blue-collar worker, maybe a day laborer in the city, maybe a shopkeep, maybe a cook at the tavern, maybe a sailor, and at this time you might have made, on average, one of these positions, around 27 pounds a year, which would have been a sort of decent middle-class income at the time. Economic historians differ on how you would estimate this, but it's not that far off from what median income would have been in the 2020s. Now imagine it's this sort of nice spring day, April 26th in 1765. Our sailor happens into the tavern. He picks up a copy of the Pennsylvania Gazette, Ben Franklin's newspaper. He sits down, gulps on his beer when he sees on the front page, Parliament's passed the Stamp Act. What do you think he would do? How would he react? He notices a number of particularly interesting new taxes. Maybe he wants to start his own shipping business and get married. Maybe he's been practicing his homebrewing techniques and wants to make spirituous liquors. Now, for each of these endeavors, he's going to have to pay. He's going to have to pay to get a marriage license. He's going to have to pay to get a liquor license. He's going to have to pay up to Parliament. So his question, I think, would be, okay, does this bind me in conscience? Is this something I need to do to be a good, just person? In other words, is this enactment authoritative? Or would he see it as tyrannical? Would he see this as Parliament imposing its will unjustly? Well, Americans quickly formed opinions on this, and many of them thought, no, this is tyrannical. But you have to take a step back, though, and try to see it from the British point of view. What had just happened in the previous several years? The so-called French and Indian or 7 Years' War, in which Parliament had gone to severe national debt. They had, spent something like 82 million pounds, and, you got to pay off that debt. And so they're saying, look, Americans, you need to pay up some. You need to fork in some more to pay off this debt. And so, from their perspective, they see this as just. Now, you can analogize to today and say, well, okay, in Colorado, if you want to, start a spirituous liquors distillery, or if you want to get married, yeah, you're gonna have to pay something. But what's the difference? Of course, you, in theory, have consented to that, or you consent to an order in which you have a say to change that law, and that was really the crux of the American complaint. We didn't consent to this. We didn't have representation in Parliament. Okay, so as I say, the pamphlet debates proceeded in these two stages. The first stage was really driven forward by that Stamp Act, and they argued about that. And then there was a second stage that came about after Parliament passed the sort of Tea Act, the coercive acts, in response to the Boston Tea Party. And then the sort of patriotic argument shifted a bit, and we'll talk about that. But each stage had sort of certain kinds of arguments that appeal to natural law and natural justice. But my argument is that natural law principles provide the theoretical underpinning throughout the debates for the Americans. So I guess we should stop and, because you can't just assume. Like, what do I mean by natural law? What is meant by this term? I mean, in the scripture, you can hear Paul talk about it in Romans chapter 2, about the law written on the heart. And indeed, in the Christian tradition, the idea that God has made known certain principles of his eternal law, of how he wants to order the world, even to non-Christians, to pagans, is clear in Scripture. The idea is something like this. It's unwritten and it's unrepealable, right? Because of the nature of the universe we live in. There's a set of unwritten moral principles, norms, or rules that we discover. We don't make them up, and which we can't just get rid of. It's natural in the sense these principles are sort of practical necessities or requirements for human beings to abide by in virtue of the kinds of things that they are. That is, in virtue of being rational animals. And it's law because these rules or norms are legally binding in conscience. And therefore, for human positive law, the law made by the state, to be binding, it has to be congruent with it. It can't be conflictual with it. So, maybe a little bit more. What is meant by these needs? Well, one of the great Christian natural law theorists, Thomas Aquinas, breaks this down and says, look, we have a threefold inclination according to our nature. First, we have an inclination that we share with all other real things, substances, to maintain ourselves in being. And it sort of progressively goes up. With vegetative and animal life, we share an inclination toward self-preservation and toward perpetuation of the species. So we can see things like life, health, bodily well-being as goods, as things that are necessary for us to pursue to be happy. And we share inclinations more specifically with the animals to propagate our species. And so, right, inclinations toward sex, coupling, rearing and education of our young. So whatever rules are accord with doing those things well would be part of the natural law. And then there are those inclinations specific to our nature as rational animals, right? Things that are proper to reason. And these are things like pursuit of truth, pursuit of knowledge, pursuit of friendship, cultivation of friendship, and indeed the good of religion, the pursuit of the truth about God. Okay, and so this sort of natural law philosophical anthropology and the account of morality that was that I just laid out was sort of transmitted and passed down through various thinkers over time, and was what imbibed the Americans' education and which they appealed to when they argued with their transatlantic interlocutors. One of the great exponents of this was James Otis. And Otis, sort of one of these forgotten founders, but he's actually quite important. He was a prominent lawyer and activist in Massachusetts. He distinguished himself by arguing against British writs of assistance. These are basically like search warrants for British agents looking for contraband. And they would search ships and shops and other places for smuggled goods. And this led to Otis, rising up and saying, no, this, you're doing this without due process is wrong. Adams actually identified Otis as the essential spark of the revolution. That Otis is the spark that lit the fire of the revolution. And so, like, Otis affirms these natural law principles. Let's get some of his quotes up here. on the basis of the natural law, he says, look, we cannot allow the idea that Parliament has absolute, unlimited authority, right? And so, let's see. So a couple of these quotes here. To push the doctrine of unlimited passive obedience and non-resistance upon mankind is to rebel against the common sense as well as the laws of God, of nature, and his country. And he also affirms, this is striking, I think, he affirms by the law of nature, human beings have a fundamental equality before God. By the law of nature are freeborn, as indeed all men are, white or black. Are women born as free as men? Would it not be infamous to assert that ladies are all slaves by nature? And he goes on, every British subject born on the continent of America is by the law of God and nature entitled to all the natural, essential, inherent, and inseparable rights of our fellow subjects in Great Britain. Okay, so to the point about the goods and the needs of human nature, he says, government is founded immediately on the necessities of human nature, ultimately on the will of God, the author of nature. What does that mean? Right? Again, those goods I was talking about, the goods that are requisite for human beings to flourish, that's the sort of immediate necessity of human nature. But, right, Otis does not believe that you can get sort of moral reality in a godless universe. Nature is created. It's created by an all-loving God and ordered, and that is what gives it these necessities a legal character. Because there's no natural law without a lawgiver, you might say. Okay, so there's two theses of classical natural law theory that you can find. First, practical reason can grasp objects that are objectively good for human beings, right? Because they're genuine needs of human nature. Things I talked about, like life, like friendship, like marriage, etc. And second, the practical necessities, rules, or norms for pursuing those goods are binding, right? They have force in your conscience, and they're indeed knowable and known by reason. And you can grasp these things by reason. Okay, right, but it's not only that you grasp by reason, you can grasp that they have what you might call a divine pedigree. They're deeply rooted in God's having created man in a specific way. Okay, and so Otis, deploying this framework, then says, look, should an act of Parliament be against any of God's natural laws, which are immutably true, their declaration would be contrary to eternal truth, equity, and justice, and consequently void. And so it would be adjudged by the Parliament itself when convinced of their mistake. Okay, so here notice there's a striking point here, that at this point in the pamphlet debates, there's still kind of a parliamentary faith. Well, you know, if we just talk it out with Parliament, they will see, okay, we'll see our error. You have, we can figure it out. We can make it for the mistake. Eventually, the founders are going to find out that Parliament is not going to correct itself. Okay, but the idea here, the key idea is that there's a higher law. There's a higher law than parliamentary-made law. Okay? Now, Franklin, he rehearses some of the standard arguments made during the pamphlet debates. He testifies before Parliament about why the Americans view the Stamp Act as unjust, and he appeals to sort of not only the English charters, or the charters of the colonies, and their constitutional rights, but also natural rights. So he kind of commingles these arguments. And so after, okay, Franklin, everyone's saying that sort of rising up, okay, fine, we'll repeal it, Parliament says. But they combine the repeal with the Declaratory Act. And this the founders are not happy with. Parliament hath, and of right, ought to have full power and authority to make laws and statutes of sufficient force and validity to bind the colonies and people of America subject to the crown of Great Britain in all cases whatsoever. Wow, okay, so we're going to repeal this, but we didn't have to. We can pass anything we want to after this if we so desire. In other words, the Americans win like a little skirmish, but the war of ideas, they're losing, at least from the perspective of the British pamphleteers and British Parliament. You know, they're not going to back down. They're not going to admit that they can't, that this authority is not in their power to do this. Okay, and so then imperial pamphleteers kind of come back, and they come back against the Americans, and they seek to cut out the Americans' ability to appeal to natural rights. It's striking. So one William Knox, he says, yeah, okay, you can talk about the laws of nature, nature's God, and natural rights and all that sort of stuff. But just because you have natural rights doesn't entitle you to any particular political rights, right? If you go, he would say, like, if you traveled over to France and say, I have natural rights, now I can vote in the French election. It's like, no, that doesn't make any sense. Your natural rights don't automatically translate into any political rights. Right, so if you claim political rights as Englishmen, you're subject to British law. And so this is a genius argumentative tactic. He's tried to undercut the Americans' ability to appeal to first principles. If you claim the privileges and rights of Englishmen, you're ipso facto subject to Parliament, QED. And so now the Americans are like, okay, we got to figure out how we're going to argue back against this. And they continue to appeal to natural law, natural rights, but they shift. They shift away from even acknowledging Parliament's authority. Remember, Otis said, "Oh, Parliament will, we trust you'll figure this out. You'll correct your mistake." And now the Americans say, "No, that's not really it. Parliament is just one more legislature in the British Empire." Right? You've got legislature, House of Burgesses in Virginia, you've got legislature in Massachusetts, and all the different colonies, and they're all kind of co-equal legislatures. They're on equal par of authority with Parliament. The only thing uniting them is the king. And so this so-called dominion theory, the idea that the king is what holds the dominion together, and that each legislature is equal, the Americans now advance this idea, right? And this was ingenious because, right, if each individual legislature is sort of co-equal with each other, then of course Parliament could not legislate and enforce its views on Virginia or Massachusetts or whatever. And Hamilton, who's pictured here, I don't know if this has a little laser thingy, I guess not, but Hamilton you probably recognize, right? The second one over from the left. He invokes the law of nature to confine allegiance of the Americans to the person of the king, right? And Hamilton, who's also pictured next to James Wilson, contends for a natural sort of justice root of allegiance to the king, again appealing to those natural law principles. And James Wilson, who's pictured to the right of Hamilton, he argues for a kind of natural rights idea underlying representation. He says, look, the Constitution, when you have elections, is drawn back to first principles, protecting the liberties of the state. So democratic elections for James Wilson, these are going to be sort of almost exercises of your natural rights. If you're not regularly consenting, being involved in the decisions by consenting to them, you're having your natural rights violated. And so this idea militates in favor of this idea that, each legislature is reflecting the interests of those people who could vote and protecting natural rights in that way, which Americans felt like they didn't have in British Parliament. Okay, and so what's the king's power in all of this? The king is like basically just to protect the peace, right? The king has executive authority to protect the empire from war, from incursion, from external enemies. Otherwise, internal matters are just left to those legislatures. Okay. And Hamilton is one founder that you can zoom in on a little bit and sort of see some of the natural law principles come out. And particularly in his argument against absolutist sovereignty. Because that's really what Parliament starts to claim, is that in that Declaratory Act, we have absolute authority to bind in all cases whatsoever. And his opponent was one Samuel Seabury, who he accused of Hobbesism. Now, Thomas Hobbes was an older thinker from the 17th century who famously argued in his book, The Leviathan, that, human beings they're really at root sort of self-seeking, self-interested, potentially violent creatures. And the only way to keep the peace is you've got to have a really powerful state, a really powerful Leviathan, and that's the only way you'll keep the peace. And, he lived through a lot of violence, civil war, and he kind of saw life through this lens, and so he sort of was in favor politically of the absolutist kings of like Charles I, Charles II, etc. Well, okay. That's not popular with the Americans. The Americans don't like those old Hobbist arguments in favor of absolutist kings. And so he said, and Hobbes, part of what Hobbes said was that, the law is all conventional. So, morality, justice, it really looks like it's just a creation of the sovereign. When the sovereign legislates, that makes something right or wrong. If there's no law there, there's no justice or injustice. It's sort of the way that Hobbes was read. And so Hamilton replies to this. The reason Hobbes ran to this absurd and impious doctrine was that he disbelieved the existence of an intelligent superintending principle, who's the governor will be the final judge of the universe. Striking. So it was Hobbes' atheism that led him to the mistake that the state is the source of all justice and right. And so now he's talking to Seabury, who's defending, British Parliament absolutism. There's so strong a similitude between your principles and those maintained by Mr. Hobbes that in judging from them, a person might very easily mistake you for a disciple of his. Ooh, you don't want to be called a disciple of Hobbes. Yeah, that's very, the Americans are not going to like that. And so he says this kind of doctrine is enmity to the rights of mankind, and Hamilton goes on to take him to task, and it's like, you need to hurry and go study the law of nature. You obviously haven't been taught very well. Okay. And so I think there's a really interesting point about this. The failure to understand divine government leads to a failure to understand human government. It's a striking idea from Hamilton, right? A foundational philosophical and theological error about the existence of a providential and moralistic and good God and his causal relationship to the world leads to a failure to understand the law of nature, and it leads to the error of absolute state sovereignty and legal positivism. Right? So if you get those fundamental theological questions wrong, you're going to get the politics really wrong, is what Hamilton is saying to us. Okay. Now, here I have a picture of one of the pamphleteers on the British side, Samuel Johnson. And he's one of the great wits of the age, one of the great lucid writers and thinkers, but he obviously comes down in favor of the British side of things. And he deploys a kind of Hobbist argument. All government is ultimately and essentially absolute, but subordinate societies may have more immunities or individuals greater liberty as the operations of government are differently conducted. In other words, rights come from government. Now, you might have some liberties and stuff, and that's fine, but government gives that to you. Right, if it gives them to you, they're sort of concessions. They are not rights claimed in the order of justice. So Johnson deploys, right, the same logic that Hobbes did, that you need to have this absolute power from which there can be no appeal in order to secure the peace. The concomitant of this view of sovereignty is the sovereign as the sole source of law, right? And therefore, the sovereign exists outside of and above the confines of law. Right, his claims all hinge on this about the nature of the British Constitution, that, in his view, could be sort of unmade and remade by the king and parliament at will. And the Americans rejected this, again, because they thought that this attributed something to government that was uniquely God's, a kind of absolute authority to make and unmake. And so, in 1774, the answers and replies to Governor Thomas Hutchinson of Massachusetts, the Patriots argued like this: supreme or unlimited authority can with fitness belong only to the sovereign of the universe, and that fitness is derived from the perfection of his nature. To such authority, directed by wisdom and infinite goodness, is due both active and passive obedience, which, as it constitutes the happiness of rational creatures, should with cheerfulness and from choice be unlimitedly paid by them. But with truth this can be said of no other authority whatever. If then nature and then of government, the supreme authority of a government is limited, the supreme authority of parliament must be limited. So the argument for limited government that we hear a lot about today, right? Limited government, that's what the Constitution is supposed to lay out. And so our state constitutions and the federal constitution lay out a limited set of powers of what government can and can't do. For the founders, that's premised on the idea that absolute power could only rest with one being. The entire logic of limited government for them rested upon this theological claim. I think that's striking. It suggests that if they didn't have that theological outlook, they wouldn't have created the country they did, I think. So the evidence, to me, suggests that there's a number of propositions we can identify as true, held by the founders. First, natural law emanates from the nature of God, in which there is a unity of power and goodness. It's not just that there's a super powerful like sky bully who says, you got to do this. No, it's that God's power is actually united with simply his goodness. And so that the rules of the moral order are, as it were, set forth for our flourishing, for our goodness, for our happiness, for our good. And this sovereign authority in which moral obligation is grounded is therefore not a result of superior physical strength, but connected to God's goodness. 2, sovereignty is a rightly ordered political community. It's modeled upon the pattern of divine sovereignty in which power and goodness are unified. Right? So just greater power alone does not justify something as binding. Right? It's got to be connected to reasonableness. The rule of law means the sovereign is subject to and bound by higher moral law. Might does not make right. Absolute sovereignty, understood as the imposition of the sovereign's will, is analytically indistinguishable from tyranny. And 4th, sovereignty originally resides with the whole people, but sovereignty remains subject to higher law. The people do not exercise an unbounded absolute sovereignty based on will alone. As such, consent is necessary but not sufficient condition for the rightful exercise of governmental power. Okay, so I'm going to try to unpack that a little bit more of what I mean by that. Okay, so the founders' belief in natural law was grounded in this sort of classical Christian origins. And, you know, this is sort of paradoxical, though, because classical Christian natural law theory, the conviction that there's a reality of a higher law to which we're all subject, was combined with this equally strong conviction. You know, we're not really good at fulfilling it. You know, we all too often fall short of actually living up to it, of how we're supposed to live. Human fallibility, in other words, or what the Christian tradition called the fallenness of human nature, was universally affirmed by the founders. Now, sometimes this is talked about in the context of a device of political theory called the state of nature. So political thinkers like John Locke, they sort of did these thought experiments, and Hobbes, of what it would be like if government didn't exist, if it fell, if tomorrow you wake up and the ICBMs have gone off, Russia fired on us and there's no longer government. What would life be like? And the founders thought, well, you know, in that condition, that would really tell you the truth about human nature. Locke thought, yeah, you might be able to get some measure of human well-being there, but it would be very precarious, difficult, inconvenient, unstable, and ultimately violent. Because people's inordinate self-love would lead them to be partial in that condition. It would lead them to be self-interested. It would lead them possibly to betray others, lie, cheat, steal, kill for their own gain. And so, right, Locke and the founders agreed, you need government to secure the peace, but Locke rejects Hobbes, said you don't need absolute government though, right? The only things that you give to government are what's necessary to secure natural rights. And part of this is because there's this fundamental problem. You need government to secure natural rights, but the second you empower it, is it going to actually turn the guns on you? How do you stop it from turning its guns on you, but you make it powerful enough to do the thing you want it to do? Well, this is central to the Americans' political and constitutional philosophy. As Madison famously put it, if men were angels, no government would be necessary. This means that human beings have in their very natures an ineradicable potential to self-seeking, to injustice, to harmful and destructive behavior. In a word, evil. Now, not as low view as Hobbes, but but also not a sort of rosy picture of human beings are essentially good and they're only corrupted by society or convention. No, there's something deeply broken in human beings, and we have to plan for that. We want to have virtuous statesmen, we want virtuous people to be in office, but we can't always count on it. And so we need to construct a constitution in mind that fractures power, that makes it so that it's unlikely or impossible for any one person or group of people to get all the power, because it's intrinsically corruptive. And the heart of man, the more power it gets, the more tempted it is to do bad things. And so the great structures of our Constitution, separation of powers between executive, judicial, legislative, these are determinations made by the founders that they thought would be auxiliary precautions. In other words, that they would help protect us against tyranny, and help make it more likely that reasonable things would be put forward, that our rights would be secured and protected. And they make it also more difficult for government to do stuff. You have to have a pretty broad consensus. You have to have a pretty broad governing coalition and control 3 branches of government in order to pass significant things. And even then, if it violates the Constitution, it can be struck down by the court. So you have to have a really wide majority to amend the Constitution. The founders, this is essentially conservative apparatus that says, there's a prejudice in favor of what has been handed forth. If it's working, then there's a presumption in favor of it. Okay, and the point there about deduction and termination. So, a natural law, you can have a law based on it in 2 ways: deduction and termination. So, deduction. It's a principle or precept of natural law: do not harm, very immediately, do not kill, say. And so, if you're basing your positive law on natural law, you might say, it shall be a felony murder in the state of Colorado, and then lay out the conditions. Okay, that's the positive law. The root of that is the natural law precept against murder. Okay, but how should we punish murderers? I've heard in recent days a lot of talk about this with the death penalty following Charlie Kirk's assassination. Right? Different states have different modes of dealing with this. Some states have the death penalty, some have life in prison, some have different modes of the death penalty. There's some open freedom here of ways to think about how to deal with, and the death penalty is an extreme example of this, but various other crimes, it's within the ambit of human freedom and prudence to punish crimes differently, at least to some degree. And that's still rooted in natural law, but it's natural law, as it were, applied in the realm of human freedom and prudence, legislative prudence. And so the Constitution itself is an act of prudence. Natural law doesn't necessarily dictate this particular arrangement of the constitutional order, but it does dictate a number of things that order seeks to protect. But it has authority within the natural law because a people's exercise of its prudence, of its desire to arrange things a certain way, is authoritative when it acts within the ambit of justice. And this is the idea of sort of we the people as being sovereign. The Constitution begins, we the people of the United States, and then goes forth, we do ordain this Constitution, etc. And that is an exercise of the people's authority, of their power. But it's not voluntarist. So by that I mean, it's not, sometimes I call this the Eric Cartman theory of liberty. I do what I want. I know that's kind of a reference I'm not sure if any of you will get. It's like people too young for South Park or too old for it, sorry. But it's not the kind of freedom where freedom means I do what I want. It means freedom is oriented toward the good, and toward the just. And so there's freedom well exercised and poorly exercised. And the founders clearly rejected voluntarism. They rejected the idea that the will itself makes something good and just. Okay. And I guess, I do want to leave time for questions, so, we have like 15 minutes. But, we the people, so this is the preamble of the Constitution. we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. The blessings of liberty, I think, is a striking phrase that we don't take notice of too often. The idea of a blessing points us back to the Declaration of Independence. It points us back to the ultimate source of that liberty, the one who blesses, I think. And so, ultimately the Americans revolt. They base their sort of revolution upon these natural law principles because, that sovereignty was that they were claiming, and that the Parliament claimed with even greater fervor after that Boston Tea Party. That was not the kind of tea the Americans preferred. They wanted liberty. Oh, my dad joke, I saved it to the end. Okay, with that, let me stop and take your questions.
When Parliament did their declaratory act,
Yeah.
was there anything similar relating to those in England? We have absolute authority to pass whatever laws we want here in England.
Yeah, good question. And this is a real sort of conundrum, really, in the Americans, because some of the pamphleteers on the English side say, you Americans want representation where you guys, it's not quite one person, one vote, but things were pushing in that direction, where you want all this representation. They say, people in England don't even have that. You have these sort of, now there was a representative system, but you had, let's say, very rotten boroughs. You'd have, there wasn't redistricting happening yet that reflected population movement in England. So the Americans' argument, they tried to use that against them to say that you're wanting something that's more democratic than people in England even have. And that's an argument they could make, but still, even that, even that argument, it couldn't go too far, because there was still some, however imperfect, system of representation that the people could have a say in a way that just wasn't really the case on the American side. There were proposals put forward about, can we have some representatives from the colonies? They didn't really go anywhere. So I don't know if that answers your question, but.
I really appreciate your book. I found it compelling. I actually added it to the John Jay curriculum when I was leading that program. I think you make the case. But upon reading the book, the John Jay fellows would say, well, what is the so what of this? If we have agreement that the American founding is based upon classical and Christian ideas, to a population today that largely rejects those, what is the so what?
Yeah. So what? Well, okay. This does bring us to something that you may want to talk about, which is the assassination of Charlie Kirk. It feels like a weighty moment. I think precisely for this reason, that to my mind, it raises the question: what is it that we even hold in common anymore? What is it that makes we the people a thing? And one of the last uniting principles was the thought that, well, all human beings have intrinsic dignity, and in virtue of that, they ought to have the right to speak their minds freely without being shot by someone who disagrees. Now, the so what question is, well, if we don't want such political violence happening, we need to recover the ground upon which that was rejected. And I would suggest that this is a moment where the so what question can be answered, because Americans are maybe being jolted. Political violence makes you, I think, or it should make you think again about what is it for America to be a people? In Federalist number 2, John Jay writes about what he thinks what makes American people united. And he says they spoke the same language, they professed the same religion and the same principles of government, and had very similar habits and customs. Now, that was a bit of a rhetorical exaggeration, because we know that while America was predominantly Protestant at the time, there was various sort of folk ways. You had the sort of Puritan and the Quaker and the Cavalier, and you had the Barbadian culture, the slave culture, so you had some diversity. And of course you had immigrants, the Quaker immigrants, a lot of German speakers coming in the late 17th, early 18th century. So you did have some diversity of language, but, right, as with any sort of founding myth, there's some truth to the claim, which was that, I think, there were certain core elements to the American public theology. Those principles of Declaration of Independence. There's a providential, moralistic God who secures and is the source of natural rights. English was predominantly spoken, but those habits and manners. I think essential to that was the family, the American family. At the time of the founding, divorce was virtually non-existent. Well over 90% of people got married and stayed married, and they had almost similar amounts of kids that I have. And right, all of this was part of the culture of the place. That this was essential. The habits and customs that united us. And then there was those principles of the political principles that united them, which I would suggest is love of ordered liberty. Right? And this is manifest in the Declaration, it's manifest in our Constitution, the state constitutions. The idea that there's a robust personal liberty that seeks to be harmonized with some notion of the common good and order. And I think the assassination of Charlie Kirk strikes at the heart of all of these things. Because if you look deeper into it, the assassin grew up in a certain ideology, a certain radical ideology that's premised on the rejection of these things.
Okay, I guess it's working. One thing I was going to say, I think correct me if I'm wrong, I think you can find a lot what they thought about, especially the moral interest, is in the Federalist paper that Hamilton and Jay and who's the other one?
Madison.
Monroe in particular did address that they thought it was important to have that religious background simply because he said the government would fail if they didn't have a moral perspective from it. And I think I've seen that a couple of times, actually.
Yeah, no, that's a good point. That Adams has the famous quote that our Constitution is made for a moral and religious people and none other. It would be our Constitution without that would be like a whale through the net. What does he mean by that? Well, the whale would be an unruly people that have unbridled passions, right? Who don't believe that they ought to love their neighbor, that they ought to give charity, that they ought to do sacrificial acts of love out of their religious beliefs. If everybody was just out for number one and willing to unleash the furies of their passions, our Constitution can't deal with that because our Constitution is one of limited government. The only way for government to hem in such unruly passions would for it to be effectively unlimited, the kind of Leviathan that the founders clearly wanted to reject. So the thought is, as Washington and Hamilton is sort of the ghost author, ghost writer of Washington's farewell address, but he says the two great pillars of human happiness are religion and morality. And a republic, you're going to be in big trouble if you reject those. And Washington and Hamilton are responding to the French Revolution, which is a great experiment in saying, hey, what if we just kick out all that old-timey religion? Let's strangle kings with the entrails of priests. Let's see how that goes. It didn't work out so great. Because then you have tyranny that rises when you unleash the passions and the furies. Bonaparte has to rise to quell it back down. Very predictable from Hamilton's perspective. That's informed by the Christian tradition. That's what he thinks would happen, and it does happen. Yeah, go ahead.
So I recently ran across a statistic that said that upwards of 90% of all the people in the colonial area were tied to the land, and I assume that means tradespeople like leather workers and blacksmiths and millers that were working with the farming community. So I think they probably had a keener appreciation for property and the hard-won fruits of their labors that I think was a unifying force as well. One, could you elaborate on that as a unifying force, and also how that would make them more resistant to taxation without representation than maybe their than their British brethren back home?
Yeah, that's a great question and a good point about. So property, of course, is central to this because it's the taking of property without your consent that is sparking all of this. And what is property but the sort of material things you have mixed your labor and effort with in the world that has generated value, and which, because you have exerted your labor and which is a function of your dignity as a human agent, belongs to you, and that should not be taken without your consent. So yes, this is central to it, and your question is about, well, specifically the kind of occupations the Americans were doing at the time. Did they give them a higher appreciation of that? I think that's definitely true. I mean, you'd have founders like Jefferson who say that, he says, basically, God's chosen people, if there were a chosen people, are the farmers, because they're much harder to corrupt. You can't, somebody who's out there, working with the sweat of his brow, raising his own food and livestock, he's going to be much less susceptible to demagoguery, to being whipped up by sort of ambitious politicians. He says, so cities are a real threat for Jefferson. It could be rotten and corrupt to people who are detached from reality, who don't go out and touch grass enough. That is, there's something to that throughout American history. And even you could argue till today that, somebody who, say, spends their entire lives online and not in touch with external reality that you have in an agrarian society, that might not have good effects on the brain. But you might also, to your point, have a less appreciation of property when you haven't worked with your hands in this really tangible way. There's probably some truth to that. I do think that the sort of Lockean founders' arguments about property can still apply with force in our service economy, post-industrial society. I think they can, but I do think that something is lost when and how in our own appreciation of property if we never get our hands dirty. Before coming out here, I had to do I had a couple plumbing emergencies, but I took care of it. Sometimes we in the ivory tower have to descend to reality too, so anyway.
My recollection was that Thomas Paine's common sense was kind of the tipping point to convince everyone to go towards revolution. I don't recall the points of common sense. Can you tell me how much of that was based on natural law?
Yeah, good question. Yes, Common Sense was one of the most popular and well-selling pamphlets in the second stage, so it comes out really close on the eve of revolution. And he does appeal to natural rights. Now, Paine is one of our, let's say, more secular founders. He later really leans into Enlightenment thinking about deism. He's quite critical of Christian revelation. But notably, in Common Sense, he makes one of his key arguments is appealing to the Bible. And he appeals to 1 Samuel, which, let's see, I actually am a convert to the Catholic faith. When I was Protestant, I used to read my Bible a lot, and I don't want to read the Bible so much anymore. That's all right, it's a bad joke. I'm trying, so hopefully I'll get my Bible verses right here. But 1 Samuel 8 is where, if I recall correctly, the Israelites go to, they go and say, we want a king. You need a king, right? All this judges stuff, it's not working. Sam's like, okay, God, they want this king. And God warns him, saying, oh, you're not going to like the consequences of that. But then finally, okay, give him a king. And the founders, when they read that, and a lot of bad stuff happens to Israel after that. The founders are like, oh, look, the Bible's in favor of Republican government, right? The Bible's against kingship. And Paine loves that. Paine says, look, the Bible is against kings. And so even though he's personally something of a skeptic in religious matters, he appeals to Christian here. I mean, frankly, it's Old Testament, and he appeals to primarily, but he appeals to Revelation, and he does appeal to natural rights. So he knew his audience, I would suggest.
It appears that one of the implications of your talk is that the founders' relative effectiveness with natural law arguments was somewhat dependent upon a shared pre-commitment on both sides of the Atlantic to Christian presuppositions. And as you kind of noted a moment ago, that's certainly not the case in this society today, which, I mean, so part of the question is, what does that say about the limits of natural law arguments today? But then what does it also say concerning a Christian public theology? Ought it to be more explicitly Christian? And in light of that, I can't help but think of our vice president, who this morning spoke part of the Nicene Creed out into the, a very explicitly Christian message from our vice president. So when it comes to Christian public theology, what are the limits of natural law arguments in our context? And in a positive sense, how Christian should our public theology be?
Oh, you saved the hard question for you. I thought I was going to escape before I had to answer that question. No, it's a really good question, and it is something I've thought about, and I don't know if I have a good answer, but a few things. I mean, I would say that there is a venerable tradition, a tradition I would consider venerable, from Washington forward, that at least in presidential public rhetoric. Now, Vance, I didn't see what you were referencing, but I'd like to go look at it. As if he's Nicene Creed, that sounds pretty specifically Christian. And you find this actually, the thing that struck me the most when I lived in Texas. For a number of years, my wife is involved in Texas public policy and lobbying, and so even still to this day, she works remotely. So I actually am pretty attuned to what's going on in Texas politics. I constantly hear in the background of this legislature talking, this lieutenant governor saying this, the governor saying that, and it is commonplace in any Texas public event to pray in the name of the Lord Jesus Christ before, after events like this. That's just what is done, because that is what is considered to be necessary to honor God as public officials. And I think that's clearly within the religious freedom to do so. At the presidential level, let's say, there's a different tradition of, let's say, under-specification of God when God is invoked. And I think that is in light of a heightened sense of religious diversity at the national level, that I think can be healthy, because we are a polity of protecting religious freedom for a wide range of groups and theists, a wide range of different types of theists, Jews, various types of Christians, Muslims, and others. So I think that there's something venerable and good about that, but I also would say that our tradition of federalism that leaves a lot more open at the state level to have more robust, let's say, church-state close relationships. Several states of the founding had established churches and continue to have so into the 19th century. And even though the Supreme Court came down in the 60s and said that you can't have the Bible in schools and prayer in schools, all of those were ahistorical decisions. They had really no grounding in the original meaning of the First Amendment, in my view, and of the Establishment Clause. So I think that in terms of the public theology question, our Constitution, let's say, perhaps leaves the space for more robust Christian public theology, more at the state level. Now, it's complicated, though, because you know. This religious liberty principle means that someone like J.D. Vance is within his religious freedom to invoke this. So I think there's got to be a balance there, prudence, in light of the reality of religious pluralism. But I think that pluralism is not so great that you can't invoke God, because that's at the foundation of our institutions. So I don't know if that's a satisfying answer, but that's a shot at it.
Just quickly, a couple of announcements. So at the end of this month, on September 26th and 27th, we are hosting a two-day event called Theology, Anthropology, and Technology. We have extraordinary speakers coming, John Stone Street, Circuit Court of Appeals. So our panel will be looking at issues of parental rights, religious liberty, and how they are often under assault here in the state of Colorado. So I hope you can join us for those. And thank you all for being here tonight. And thank you again, Kody.
Thank you.